Hello friends, welcome to the Criminology segment of UGC EPG Pathshala. I am Suman Dash Bhattamishra, Assistant Professor of Law at National Law University, Odisha. Today, in the segment of Fundamentals of Criminal Law and Criminal Justice, I will be discussing with you the module of Introduction to Crime, Origin and Development. Before I begin, let me introduce the topic to you. It has been a matter of contemplation among scholars always as to whether man is more disposed to crime as a savage or as part of civilized society. However, what is settled factually is that man has always shown the potential to work against established rules of social order. In other words, while the propensity of human beings to commit crimes may vary relatively from one stage to another, it is an established fact that they always have the ability to commit crimes. What is this ability to commit crimes? Why did we develop rules for penalizing crimes? What is the problem that crimes pose for civilized society? There are 1,000 questions that can arise in this context. So as we try to dive deep into the topic, let us first try to understand the evolution of criminal law in primitive society. Now, rules of commission and omission have always been part of all civilized societies. Human society is about establishing norms. It is about establishing rules and regulations which guide human conduct. Civilization has always been known to depend on certain principles and norms, the absence of which makes society savage. If it doesn't make society savage, it creates indiscipline and therefore discomfort for all members of society. Whether a certain series of acts will be punished and which of such acts will be punishable has always depended on public opinion, beliefs, social standards of rejection and acceptance. They have also played a very important role in determining the do's and don'ts of society. A set of beliefs, values, norms, public opinion, customs, traditions, they have all had an impact on the shaping of law. Likewise, their impact has also been significant in the shaping of criminal law. For example, in primitive society, retribution or deterrence as models of punishment were more popular than the more modern punishment methods, like for instance rehabilitation, reformation, etc. of the accused. The focus of punishment was on severity, as the idea was to render a permanent incapacity among people to repeat the commission of crimes so that there is no scope for repetition at all. The history of criminal law is very fascinating from this perspective. The gradual transition of punishment from mutilation of limbs of the offender to his reformation is also very interesting. I mean, imagine a society where the only known modes of punishment were either to wreak revenge on the individual who has committed a certain wrong, or the idea was to prevent him from committing a certain wrong by inducing fear in his or her mind. And now we have advanced so far as to think that we can talk about taking the evil and distinguish between the evil and the evildoer. That is where rehabilitation and reformation are considered to be modern punishment mechanisms. The idea of self-preservation is the natural instinct of man. To think about it, the development of criminal law is a reflection of the growth of discipline at the levels of individual as well as the family. So, there are certain rules which must guide our conduct not only as individuals but also as members of the family. When this level of discipline is taken very high, that is where we think of having sanctions for certain actions or having natural consequences which are remedial in nature for those actions. The natural instinct of man to preserve himself has been emphasized in family, from which over a period of time clans developed. Criminal law at that point of time drew its strength from disciplining the family, which then slowly developed into disciplining the clans, and from there indirectly it started disciplining the society. So we see that this transition of criminal law has had its roots at the level of the family. Discipline in the family then gradually developed into discipline of the clan, and from the discipline of the clan we developed into a discipline of the society as a whole. So this structure was important. According to Maine, criminal law was not different from civil law in primitive stages. On the other hand, according to Diamond, the distinction between criminal and civil law was always visible, even in the early stages of society. In the first and second agricultural grades of society, codes seem to have appeared first. In these codes, rudimentary criminal law seems to have been in practice. So Maine and Diamond have different perspectives on the presence or absence of criminal law in rudimentary societies. However, the range of actions that comes within the domain of criminal law was highly limited. There was no systematic trial at this stage. Chiefly, the crimes that were made punishable at this stage were witchcraft, incest and bestiality. According to Diamond, these crimes were not crimes that could be committed without mens rea. The age of codes. Now, when we talk about the age of codes, it's a very significant age in terms of the development of criminal law. So, the second stage that we will be discussing now is the age of codes. As society progressed, it started becoming more compact. More compact as in, it started coming together in the form of a wholesome unit. Primitive society gradually progressed into the era of codes, and criminal law was codified during this phase. In the era of codes, the idea was to write down the law. Writing had a more permanent and relatively lasting impact in terms of bringing different rules together. It brought about more permanent impact in the sense that in terms of having confusion relating to what the rule was or what the regulation was, there was absolutely no problem. Now, what codification did as a consequence was that it started laying down permanent rules and regulations. The permanence started getting down to human civilization as a bunch of rules that were non-negotiable. The earliest codification of criminal law was in the form of the Code of Hammurabi, which was developed in 1754 before Christ. It was a small volume of criminal law. There was more emphasis on civil wrongs in this codification, with some antisocial acts being given the status of crimes. So crimes, as we see, are a development in the law in terms of their seriousness. So those wrongs in early societies which were considered to be more serious than other wrongs started acquiring the status of crimes. The degree of seriousness of these acts also determined whether or not they received the status of crimes. For example, if you see, disloyalty towards the king was considered to be a crime under the code. Resistance to the power of the king was considered to be an assault on the king's dignity, and it qualified as criminal conduct. The king in those days was considered to be the supreme power holder. He was the one from whom laws emanated. So When we talked about codification of crimes, the highest form of crime that one could think of was going against the king. The administration of criminal justice was primarily through king's courts. Such offences which were designated as criminal were tried by king's courts. Victims were compensated on the basis of their degree of vengeance. The history of criminal law passed through very interesting stages, which were 4 in number. The first stage was one where the idea of injury was towards the state of collective injury. The state permitted the wronged individual to avenge himself. So it was considered that in this stage, it is the state which is getting hurt out of crime commission. So collective injury was considered to be the basis on which an accused was to be punished. In the second stage, as the occurrence of crimes increased and their frequency multiplied, the state delegated powers to commissions. These commissions were entrusted with the task of investigating the crime and punishing perpetrators. In the third stage, the need for having permanent commissions to deal with crimes was felt. And so, such commissions were created and appointed by the state. Now, the commissions were considered to be representative in character. These commissions represented the state or the collective unit. In the fourth stage, the permanent commissions now gave way to permanent benches, which were called the questionees. At this stage, specific offences and their corresponding penalties were also listed. It is to be noted now that in these stages of development, criminal law had a limited area of operation. The well-known offences during this time were witchcraft, etc. Punishment methods were guided by the principle of eradication of these crimes rather than rehabilitation methods. The history of criminal law is enchanting and is closely connected with the development of the law of homicide. Homicide was considered to be a civil wrong initially, which was addressed by civil actions and not prosecutions. Intentional homicide was punished by death and confiscation of goods. Isn't it interesting to understand how homicide was considered to be a civil wrong initially? Perhaps the idea was that when somebody kills another individual, it's an action which is extremely private in nature because it's ultimately a dealing between the two people. And the privacy of homicide, obviously which is not so in current and modern societies, was considered to be of something very natural in those times. In the Hebrew code, capital punishment was provided for homicide. Capital punishment was considered also to be the highest form of crime. In fact, in relation to homicide, that is the act of killing individuals, many different forms of punishment have been prescribed in different laws. So for instance, sometimes it was the victim who was given the right to kill the person who had killed any of his family members or near and dear ones. So apart from the state, the victim was also given the right to avenge himself. Now we will go through another important segment in criminal law, which is the Roman criminal law. The Roman jurisprudence has impacted all systems of law everywhere in the world. The oldest part of criminal law has been captured in the 12 tables of 420 BC. The 8th table, also known as De Delictis, dealt with the law of crimes. There are 26 items in this table which deal with various crimes. Roman lawyers divided crimes into 3 categories. Let's take a look at what those categories are. Publica judicia was the first category of these crimes. Extraordinaria criminal, this was the second category. Privit delicta, this was the third category of crimes. The publica judicia, what was it? What did it talk about? This is something we need to discuss. Publica judicia deals with crimes which are specifically forbidden by particular laws under serious penalties like the death sentence. The second category of crimes, which were known as extraordinaria criminal, they were crimes for which no special punishment was provided. Punishments for this category of crimes were left to the discretion of the judge. That means the judge was considered to be the sole person to decide what should be the quantity of punishment in such cases. Under this category, family offences were included, as well as offences like the introduction of a new religion, raising the price of corn, etc., which were considered to be pretty difficult offences under these categories. The third category of crimes was called publica judicia. Now it included those offences which were prohibited by various laws that were passed from time to time. In its more advanced form, Roman law also consolidated crimes in several codified documents. Lex Julia Majestatis, this was one such thing. It included offences against the state. Likewise, Lex Julia de Adulteris, these laws covered sexual offences of all categories. Lex Julia de 6 Publica et Privata. The Act consolidated several earlier laws which penalized acts of violence but did not fall under the category of offences against the state. The next set of such laws were Lex Cornelia de Sicaris Veneficis. This set of laws included homicide but excluded from its domain killing by negligence. However, killing by administering poison was included within its purview. Privata delicta, this consisted of private wrongs like theft, that is taking away movables or valuable security. In order to constitute the offence of theft, it was to be shown that the stolen article was in possession of the same person who was accused of taking it. Under Roman law, taking property by impersonation also amounted to theft. The principle of punishment was not very objective and depended on the feelings of the victim on most instances. There is significant literature in the area of Hindu systems of criminal law and criminal jurisprudence. Vedic society has always emphasized on core patterns of moral conduct in society, the violation of which was severely discouraged in ancient times. Arthashastra, Yajnavalkya Smriti, Manusmriti, etc. are all very important treatises revealing elements of criminal law. Chapter 8 of the Code of Manu or Manusmriti, as it is commonly called, refers to a secular method of trial and also lays down rules which must be followed by the king for trying offences. Manusmriti also lays down that it is the solemn duty of the king to try offences personally, and in cases where he is not in a position to do so, he must appoint learned brahmanas to settle disputes. This reflects the emphasis of Vedic society on adjudication of disputes and prescription of penalties for the commission of offences. Now, the Manusmriti also refers to several types of crimes like assault, battery, gambling, defamation, theft, robbery, etc. Added to these are offences like cheating, trespass, transgression, fornication. After taking or making a mention of offences, Manu also prescribes punishments for them. It is interesting to find that Hindu conceptions of criminal law also provided for exceptions in the presence of which the unlawful acts would not lead to fixing of any form of culpability on the offender. Like in modern times, the defences of necessity, infancy, insanity were known to Hindu scholars of law. Methods of punishment in Hindu system of criminal law were premised on well-developed and logical principles. The idea of proportionality was embedded in Hindu philosophy, and there seems to have been a graded pattern of punishment. The graded pattern of punishment is interesting to note, considering that Hindu systems of criminal law were much earlier than modern notions of criminal law. For example, there is reference to various types of punishment like censure, rebuke, fine, forfeiture of property, and then also corporal punishment in Hindu law. Corporal punishment as a method of punishment was resorted to in cases where crimes committed were grave and serious. Corporal punishment also included imprisonment, banishment, mutilation, and of course the death penalty. Various principles were laid down and several factors had to be taken into consideration before deciding whether or not a certain punishment was to be imposed on the accused. The idea was to ensure a fair and reasonable standard of punishment which was commensurate with the then prevailing standards of justice and its moral norms. The various factors which were taken into consideration were the nature of the offence, the time, place and manner in which the offence was committed, and apart from that, the strength, age, occupation and wealth of the accused as well as the victim. Since we went through early Indian society's take on criminal law by referring to Hindu form of criminal law, it would now be apt to also take a look at the Islamic system of criminal law. In Islamic law, we have faced criminal law and had a different take on it in the manner that it is a big book-based law. That means it derives its form and content from the Quran, and its prescriptions pertaining to criminal law are also derived from the Quran. Other than that, various other sources of Islamic law like the Hadith or Sunnat, Ijm and Qiyas also contribute to the development of substantive criminal law. A threefold punishment pattern is to be seen in the Islamic system of criminal law, namely, first of all, retaliation, composition, and then deterrence. Apart from these three modalities, personal retaliation was also permitted. The office of the Qazi or the judge was hereditary in ancient Muslim society. There was a well-defined provision for punishment, and they included mutilation, death and fines. Now, let us take a look at development of criminal law in British India. When the British entered India, the system of criminal justice in place was the Mohammedan criminal law. According to Stephen, laws administered in India at that point of time were utterly confusing and indeterminate. In 1773, the very first attempt was made to impose the English system of laws in India. Accordingly, new courts were set up with a different hierarchical structure to ensure smooth implementation of the laws, and further reforms in justice administration also were made. In 1793, the reforms included the setting up of appellate courts in 4 major towns of Calcutta, Dhaka, Patna as well as Murshidabad. The most significant development in the domain of criminal law, however, was the enactment of the Indian Penal Code. Short penal codes had been drawn out for Bombay and Punjab earlier. However, under the Charter Act of 1833, a single legislature was introduced for the entire country. In 1837, the draft penal code was submitted. After a lot of changes, finally in 1860, the code was applied in India. This was a brief history of the development of criminal law, and the attempt here was to introduce you to the origin and development of criminal law. Right now, I would like to conclude the topic for you. The development of criminal law as we see in its modern form today has undergone a slow and very interesting phase of transition. From mutilation as a form of punishment to rehabilitation and reformation as punishment mechanisms, the change has been really fascinating. So as to summarize, in the primitive age and initial days of development of criminal law, the focus of punishment was on severity of the penalty, as the idea was to ensure that people were permanently incapable of committing crimes. The emphasis here was on bringing about incapacity in relation to commission of crimes. The development of criminal law is based on the premise of self-preservation. It means that man has a natural instinct to preserve himself. Criminal law evolved by way of preservation of the family, and then interestingly it went ahead into preservation of clans. From there it evolved into preservation of the state. The oldest part of criminal law has been captured in the 12 tables in 420 BC. The 8th table, also known as De Delictis, dealt with the law of crimes, and it consists of around 26 items which deal with various crimes. Many important treatises on criminal law are to be found in English law. Of these, the most prominent one is The Mirror of Justice, which was written in 1066 AD, and it is believed to be the oldest book in criminal law. Hindu and Muslim systems of jurisprudence have also impacted the development of criminal law. With this, I would like to conclude this segment for you. Thank you. See you again later.